All right. Good afternoon, everyone. We're back for our second or third voting session of the day. Surprisingly, everyone came back, so we're going to start. We're going to start off with the independent investigations, and then we'll move to no-knock. So I'll just give a little bit of background for where we've been and where we are now, and then I'll have counsel read the proposed amendment. So started off, you remember, the summer with the independent investigations being housed in the Office of State Prosecutor. There were discussions around accountability because that position is appointed to a 6-year term. There were also discussions about capacity because of the relatively lean staff and the potential workload. I think they have something like 6 employees. And then the general idea of having an independent person have kind of concurrent jurisdiction with the state's attorneys in their local jurisdictions. So then, taking the feedback, from the summer, offered a different model with the Office of the Attorney General, those responsibilities being housed there. Same model essentially the same model, not apples to apples, but essentially the same model as what the Office of State Prosecutor does with their investigations for public corruption, which is they would do the investigation, they would make a recommendation for prosecution, do investigation and make a recommendation to prosecute or not, and then give the state's attorney within that local jurisdiction 45 days to prosecute or decline to prosecute, at which point the Attorney General could step in and do it. So again, conversations about resources, and at the end of that conversation and in the work group, I thought about just being more prescriptive about having the Maryland State Police do it. Maryland State Police already does, or already and Senator Bailey, correct me if I'm wrong, but Maryland State Police already handle a number of these types of investigations for our more rural jurisdictions, and because their local police forces can't exactly handle something as sophisticated and labor intensive as these type of investigations. So it seemed to me to be a pretty good model. Even got a fiscal kind of background, went, as I promised, to see how much it would cost. But then, through further discussions, Senator West, Senator Heddleman, and others decided upon not so much of a drastic step. Also spoke in taking into consideration what the state's attorneys have said and lobbied hard on, decided to go this route. And so it's, I'll let Jamie explain it, but essentially it expands the scope of what would be involved slightly. So not just officer-involved death or officer-induced death. It would be serious bodily injury as well. And essentially it would, for a potential incident involving the death of a person caused by a police officer, the state's attorney having jurisdiction to prosecute the matter shall transmit a copy of the investigatory file. That's it. Is this it?
Serious bodily injury.
Yeah, we can add that in. Shall transmit a copy of the investigatory file and any other relevant information to the Office of the Attorney General within 10 days after the state's attorney's decision not to prosecute the law enforcement officer for a violation of Title II of the criminal law article. After conducting the review of the investigatory file and completing any additional investigation, the Attorney General determines that prosecution under the Title II of the criminal article is appropriate. The Attorney General may prosecute. So essentially, it gives the local jurisdictions the first bite to investigate and decide to prosecute. The Attorney General will then review it if there's an interest in doing so, and then we'll have that option to kind of take a peek and take action. The second part of this proposal, and I don't see it here. Okay, here we go. It establishes a task force basically to study the feasibility and utility of having independent investigations of this sort in the state of Maryland. It'll have one member of the Maryland Senate, which I assume would be me, since I've created it, one member of the House of Delegates, the Attorney General or the designee of the Attorney General, state prosecutor or state prosecutor's designee, president of the Maryland State's Attorneys Association, that's the same thing, superintendent of the state police, and GOCAP would basically staff this. They would produce a report due next year, and that's essentially the sum and substance of the bill. Took a long time to get to just this, but I think in taking the feedback from everyone from across several months and just the fiscal concerns, it probably makes more sense to get more information, but I think this model, I think, Senator West, for working with me on this, is fair and a kind of a prudent step forward. Senator Castley.
So, I mean, look, this is probably, there's some good ideas in here. I would agree with that. There's some, I think it's a much better, with this amendment, it's a much better bill. My thought would be as to why we go with the Attorney General as opposed to the Office of State Prosecutor. And the reason I bring that up is the intent is to totally depoliticize this. I mean, nobody's saying that the local prosecutors couldn't do this right. The issue is will they be too tainted by politics, where they feel constrained that they can't effectively prosecute somebody who ought to be prosecuted. So that's our concern, is politics. So if that's our concern, then I think we ought to be looking at how to make this as least political as possible. The Office of the Attorney General has not infrequently been used as a political stepping stone to the governor's office. And those gentlemen and ladies have every right to do that, so I'm not knocking that. But it's just that puts you in the political hot seat. And state prosecutors, they just sort of, like old generals, just sort of fade away. They be state prosecutor for a while, they do their appointment, and then they just go back into private practice somewhere. And they do this for a while. And I think their likelihood of being influenced by political interest would be much less. And we know they already do this kind of, I mean, they do have jurisdiction currently to investigate, what do they call it, violations of, people who violate their public office, and police officers hold a public office, so they have the right to do that. And what we'd really be doing here is giving them an oomph and saying, okay, state attorney, you got to give him that entire investigative file, and we're telling the state prosecutor, and then you got to review it, and then make a finding. So that'd just be my suggestion. I think this is really a very interesting bill with a lot to offer, because this goes along that spirit of we've got to make people understand that the decision was not a political decision and was. So I think the state prosecutor does that. Thank you.
No, point well taken. I got to tell you not to tip my hand too much, but I was agnostic as to where it would go. I just thought that the whole idea of independence was important. I've been trying to figure it out. I think this is so if it's the Office of State Prosecutor or the Attorney General, I honestly would defer to the wisdom of the committee, frankly. I mean, I'm not. The whole thing was to get independence, and whether it's Attorney General or Office of State Prosecutor,
Office of State Prosecutor, because we said, well, he doesn't have the investigative ability. But under this bill, that doesn't really matter, because he doesn't need to have all those cops. And that was the big concern is, I mean, you need for a case like this, maybe 3 prosecutors. He's got that. 3 prosecutors and a staff and a budget to do it. So if he's taking somebody else's file, and then he can rely on the state police to supplement him for logistics for trial, which he's already got the ability, and I think all the concerns that I had on the state prosecutor are eliminated by the way you've structured this. So thank you.
Thank you, Mr. Chairman. As the most junior senator on the team over here, so I wasn't privy to your September forward meetings. As you probably have gathered, that the House proceedings were handled a little differently than what we're doing here. But so my concerns are, and hopefully I can get them alleviated. My concerns are, having been a constitutional officer, sheriff elected by state's attorneys elected the same way, and the fact that the duties assigned to them are being sought to be given to someone else. They're elected by the folks to prosecute. So I'm trying to understand the amendment. Does the amendment say that the prosecutors, because I think in the short time I've been here, we talked about a number of things. The prosecutors, local prosecutors, get the first stab at the investigation, and if they choose not to, then it moves to someone else. But if they choose not to, then you're then authorizing.
Yeah. So if they choose to go forward, then obviously no one else can jump in, because But if it's like sitting in their declination stack, then, and there's like an air of kind of something going on, impropriety, suspicion, something's not right.
So
It
I
would
guess we're looking for qualifiers, right? So if
Yeah.
So if there is a law enforcement involved fatality, death, someone dies in custody or from an incident, and if the state's attorney's office and their investigators say, we've investigated this extensively, and we don't see a reason to go forward, we don't find any fault with the officer, this is a death that was incidental to whatever occurred. So who qualifies that getting sent? So are we saying every police-involved incident that results in a death should be prosecuted?
So the state's attorney would, within 10 days of the completion of, whatever their action is, so if they've decided not to prosecute, within 10 days, they have to send it, and this bill would be the Office of Attorney General for them to look at. And then they would, review the record and then say, okay, we actually think there is something here, we're going to go forward with it. So essentially, it gives the state's attorney the first bite at the apple. There's no deprivation or abrogation of right.
So,
Senator Bailey, we had this conversation, I think, yesterday, and I looked it up, I found it, the case. So then, you're right, you're absolutely right. There's a 1975 case, the name escapes me, I don't know if this is the case site, but then the very next year, the General Assembly came back and passed a constitutional amendment, so it went through and it got ratified. It was on the ballot. Steny Hoyer was the author of that, by the way, in the Senate. And so now, essentially, and this is according to I'll forward you the opinion, that the last two bills for the Office of State Prosecutor or the Attorney General, those are constitutional. As long as you don't abrogate or remove responsibility such that it would basically eliminate the purpose of the office existing. You take away all of their rights and all of their responsibilities. If it's narrowly tailored and confined to a narrowly tailored reason, then it would be constitutional. They've opined on this. I don't think it's been challenged. I think it was challenged once. It was challenged for the Attorney General to have the ability to prosecute fraud in environmental regulations, and then one other case, I can't remember what it was, but two instances I think it's been challenged and it was upheld. But this doesn't touch that because the state's attorney still has the first bite at the apple.
So, and just one more question, I think. So, state's attorney has within 10 days of the decision to send it up. Okay, all right. Let me think.
I do think Senator Hedelman had her light on before I did.
Was it me? Oh. Thank you, Mr. Chairman. Who's the investigating force in this? Is it in the jurisdiction where it happened? It is.
It happens like normal, like it happens today.
Okay.
But there's an additional check,
Right.
the ability of some independent eyes to come in.
Gotcha. Okay. Thank you.
So I would say, Mr. Chairman, thank you very much for the changes because of the fact I feel pretty strongly about the fact that the state's attorney should definitely get the first bite of the apple. I think that they are the most familiar with the court system. They are the most familiar with the investigatory agencies in their county. I think it would work very fluidly, having an ability to get the state prosecutor or the attorney general engaged. I would have to say that based on my experience, that the state prosecutor's office is much more thorough and much more engaging in a process such as this. Some of you know a little bit about my background, but I found myself in a corruption case involving police department that I worked for. Met a state prosecutor, and we ended up indicting one of the high-ranking officials of the police department and having a full-blown trial where he was ended up incarcerated as a result of it. And I was a witness there. If it had been handled through the Attorney General's office, with the way the current Attorney General's office works, I'll have to say I have a difficult time sometimes even getting opinions in a timely fashion. Right? They do not have the resources. I have prosecuted cases in almost all 24 jurisdictions in this state, and trying to get help from the Attorney General's office to do that has always been a struggle. But when we talk about something like this, the state prosecutor's office has extremely experienced investigators, right? They have the quality people that work for them, and this is not a fly-by-night job for them. They can evaluate and look at evidence. They're familiar with this type of situation that would be involved, and they can then work hand in hand with the local state's attorney's office. So I would offer the fact that based on my experience that if you were willing to look at it, I think the special prosecutor's office would be a better fit than the Attorney General.
Sure. That amendment would be on there. I know as Senator Sidnor just wanted to comment first, then we can move on Senator Bailey's amendment. I'll just say it. So it was the Murphy v. Yates. So that was 1975. So you were spot on with the year. And the two examples I was looking for, the Attorney General has previously granted statutory authority to the Attorney General to either exclusively prosecute certain specific criminal offenses under state law, which is organized crime, and then the other one was falsification of environmental permits. Those are the two examples I was looking at. So, Senator Sidnor.
No, I just wanted to comment that while I certainly do believe that the Office of Special Prosecutor could do the job, I think the way that the bill is written is the best way. I know in having conversations with some of my colleagues from the city, this is where they want to see it, and I'm certain that if it was changed, I don't know whether or not we'd have that support. So I would just advise that we keep it as it is. Thank you.
Saying keep it as it is. Do not move it from the Attorney General to the Office of State Prosecutor. He's in the city. Okay, your conversations were that. I didn't catch the first part of it. Sorry.
I think keeping it with the Attorney General's office is the right thing to do.
Thank you, Mr. Chair. I'm interested. I've never heard any negative comment on the state prosecutor, so I wonder why, if Senator Sidnor knows, why people he's talked to are not enamored of the idea of having the state prosecutor handle this.
There's concerns about the office's diversity, its track record with prosecuting black elected officials and the like. So that those concerns have come out, I think, after the hearing that we had earlier, or the conversations we had on the bill earlier. So these are some of the concerns that have been expressed. So I just wanted to put it out there just so that you all were aware.
Okay.
I neglected to mention it because I didn't want to take too long explaining it. But so in the first version, we did have some measures to ensure that there was diversity in recruitment and retention for professional staff within the Office of State Prosecutor, and they were very helpful in developing that framework. So, those concerns were raised, and they were I tried to address them in that version. So that's not I've heard that commentary before. Put it that way.
I would move the amendment for the Office of State Prosecutor. We make a decision one way or the other, just because the Attorney General is clearly highly politicized. I mean, he spent the last 4 years playing federal politics, and so it's a very highly politicized office. And obviously, the state prosecutor is not. So.
Sorry, go ahead, Vice Chair Walsh.
Thank you, Mr. Chairman. I'm not sure the necessity of talking about the Attorney General in those terms. I think this Attorney General has been extremely competent, thoughtful, and obviously has taken a role vis-a-vis the previous administration, but as a general matter, and as chair of this committee, was considered a bipartisan, thoughtful senator. That said, if we're going to depoliticize these and create a true independent investigation, I do agree that that trust is better created in the Office of State Prosecutor, which has shown itself to be an independent investigator in other contexts. So I'm going to support the amendment without all the disparaging of our current Attorney General.
No, I couldn't, hold on, I'll comment afterwards, but,
I don't think it was disparaging, it's a fact.
sorry. I'll,
Look at his Twitter feed. I'm not, look, I'm not disparaging. He spent the last 4 years, like every other tweet and lawsuit was about Donald Trump. I mean, it's just a fact. It's not like I'm making it up. It's true. It's politicized. It's a highly politicized office. I'm not saying, it's just a fact.
Thank you. There's no sense in getting involved in talking about the Attorney General. He's always been, I found him a good friend and very competent professional. But it seems to me that it would make some sense to put the state prosecutor in now, but you're going to have this task force. And the task force is going to report back in a year, and I noticed that both the state prosecutor and the Attorney General are on the task force. So if the conclusion of the task force is that the Attorney General ought to do this job, we could amend this a year from now to substitute the Attorney General for the state prosecutor.
Fair point, and want to echo the sentiments of the Attorney General. Has been obviously a consummate professional and has been a competent steward of the position.
He's great.
And is a stellar friend and to this committee and to the Assembly and to the state of Maryland. All right. So the amendment has been moved. I think Senator Bailey made the amendment, and I think Senator Castley seconded it, or it's been seconded. So we'll let me actually, before we do that, we got amendments on amendments. So let's adopt this amendment first as a baseline amendment, and then we'll go to Senator Bailey's amendment. Okay. So is everyone okay adopting this? Great. Now Senator Bailey's amendment's on. I sense there may be just some division, so let's just do a roll call and we'll go from there.
Vice Chair Waldstreeter.
Yes.
Senator Lee.
Yes.
Senator Castley.
Yes, and I compliment the chair in crafting what I think is a pretty good bill.
Senator Hedelman.
Yes.
Senator West.
Yes, and to explain my vote, which I don't think I've ever done before, I was somewhat critical of the last bill. I think this bill is a model for how this committee ought to work, working together to try to achieve a consensus. And I think we've accomplished it. So with great pleasure, vote yes.
Senator Sidnor.
Yes.
Senator Jackson.
Yes, and explaining my vote or qualifying my vote or to add something to my vote, coming from a budget committee, state prosecutor, attorney general, staffing matters, those things. While we're a small state on the map, we have 150 plus police agencies. So staffing is a qualified staffing is always going to be a concern. So I hope we have some sort of mechanism that we can capture that. Thank you. I vote aye.
Senator Bailey.
Yes.
Senator Carter.
Yes.
Senator Huff.
Yes.
Chairman Smith.
Yes. All right. So now the bill is amended and is before you. We have just one technical correction, and then I think we may be ready to move it.
So just a quick technical note, in the amendment, the language is tied to violation of Title II of the criminal law article, which is homicide crimes. So it just says that the prosecution, it would kick in when the state's attorney determines not to prosecute the law enforcement officer for a violation of Title II of the criminal law article. So because that's homicides and because serious bodily injury is in the amendment as well, we would want to strike that that reference to Title II. And the one possibility is that the committee could just say decision not to prosecute the law enforcement officer for the death or serious bodily injury, and just reference back to what the investigation was for.
Bodily injury, I'm missing, I'm looking at the amendment. Where is that?
Oh, take.
Just death, to keep it as death.
Keep it as
Yeah,
death?
yeah, yeah.
Okay.
What?
Then
Pared down more, not serious bodily injury, just death.
I'm sorry, I didn't think this bill, I thought this bill
Right.
covered death.
no, I guess at the beginning of the introduction of the amendment, the chairman had mentioned serious bodily injury,
Okay.
which I hadn't actually included in the original text. So I guess it's just a mix-up.
That's my fault, and he is right. That's why
is
it's
right
not. It's
that
not
way.
in the bill. I said it incorrectly, and he was referencing what I said. So
Okay, so we don't need to change this because the violation of Title II is right.
correct.
Okay. All right. I mean, I'm going to vote for this bill, so I need to know what I'm voting for, okay?
And to Senator Jackson's point, I know we'll look into that for the. I'm keenly aware. Yeah, that's funny. We don't usually deal with that, but the
And
pins,
you also added in the "and" that was missing between file.
the money piece.
and- Okay. Just a technical.
That capacity piece is vital because if we're looking to address the public's concerns, we can't have a prosecutor, state prosecutor, not act on something that goes to another prosecutorial level, and then they don't have the manpower or the capacity to do it. So that's the reason I raised it. Thank you.
There was an "and" on page 3 of the reprint, after line 11, 1, 2, 3 lines down, it says investigatory file, it should say "and any other relevant information." You see what I'm reading that? Yeah. And any, that's all. Do we need, just ask you, should that be that the coroner determines is caused by the death of a police officer? Is that? What's that? So that's how we would determine that? is
Yeah.
it?
Yeah.
I'm just wondering if we just specify that out.
The fiscal note for the last one said that. That's how it happened. But I don't.
I mean, I think that's what, I mean, the coroner would issue a report.
Yeah.
That would say this was a death was caused by whatever. Whether that, I mean, that would be what I would think we would do, but if we don't need to, I'm fine. Okay.
So before we vote on the bill, I just wanted to kind of mention an idea that I had referenced during the work session and see whether it's possible to integrate into drafting, if that's okay with you, Mr. Chair, which is I believe that a decision not to prosecute, as referenced in this bill, will be perceived as a decision on the merits. I don't think there's enough evidence to prosecute, or he didn't do it. But I also think that we should provide the state's attorneys with an opportunity to hand the case over to the state prosecutor without a decision on the merits and say, I want an independent investigation here without me having to decline to prosecute, because that will look as if I have a position on the merits. And I want that true independence. I want the state prosecutor to handle it. And so I was just talking to counsel, and I'm just curious if there's an appetite to allow the state's attorney to pass the file, the investigatory file, to the state prosecutor without a declination.
I mean, state attorneys already have that option, at least with regard to another state's attorney. I mean, any state's attorney, I mean, it happens all the time. They turn to the neighboring state's attorney or any state's attorney and say, I mean, it doesn't have to be the special prosecutor. If the state attorney wants to give it up because they feel an obligation, why bug the state prosecutor? Turn to another county. It's fairly commonly done that they could just give it to a different county and say, you decide. So it seems to me the state prosecutor's only coming in because they're questioning the judgment of the state's attorney as whether they want to prosecute or not. If the state's attorney's already made that judgment, I don't want to touch it, give it to the state's attorney. The statute isn't really, I don't see a need for that.
Okay, just wanted to throw it out there.
It's really commonly done to pass it off to a fellow state's attorney who's going to prosecute for you because you feel uncomfortable.
Got it. So you're saying if the state's attorney doesn't want it, but doesn't want to affirmatively decline it, just give it to
Another
a
state's
neighboring
attorney.
state's attorney.
Yeah, go ahead and do it. It's all the time. And it seems to me the reason we're bringing the state prosecutor in is because we're really it's a check on that state's attorney to say, why don't you want to prosecute this? And that I get. I understand that. But they're already saying, because I have a conflict. Just by doing that, they're saying, I feel like I need to get this out of my hands. And then we don't need a check. The whole check and balance is irrelevant at that point.
Got it. That's fair. That's a fair place to land.
All right, Senator Cassidy, go ahead. You want?
I'm good.
Okay, good. All right, so I'll motion for favorable.
Second.
With amendments.
Vice Chair Wildstreicher.
Yes.
Senator Lee.
Yes.
Senator Cassidy.
Yes.
Senator Huddleman.
Yes.
Senator West.
Yes.
Senator Sidnor.
And to make certain I'm understanding, it's the ability for the state's attorney to make a decision to hand it over to the Office of Special. Am I understanding that right?
Both and for the Office of State Prosecutor to step in and say, look, something doesn't look right here. Why didn't you choose to prosecute?
Yes.
Senator Jackson.
Yes.
Senator Bailey.
Yes.
Senator Carter.
Yes.
Senator Huff.
Yes.
Chairman Smith.
Yes. You may like a couple of these, actually.
Does it, well, I mean, does it still say you can do it?
But I got to tell you, that's a broader conversation because if you ban it, then it's going to migrate to knock and announce, and then they're just going to find. I feel like you have to broaden your aperture of reform of that because if people are just going to get more. And the two law enforcement officers can explain this better than I can, but I feel like if you banned it outright, wouldn't people just go to get knock and announce? And I remember State Attorney Riley in particular said that the knock and announces had greater fatality rates, were actually more dangerous.
I don't know if you produce any data to that extent, but that's what I said it.
Yeah.
So basically,
But
can we just go through what the amendment does?
Yeah, can we just, everyone knows, yeah. Do you want to do just a quick, a very high-level synopsis of what the bill does, and then we can walk through the amendment?
She passed it out. It's 419, several pages. Sandy passed it out. Should be on your desk. If not,
Yeah, I may have put it on your chair if you weren't.
did you find it?
Yep, that's it. You're welcome.
So this is Senate Bill 419. What the bill does is it repeals the authorization in current law for the issuance of a no-knock warrant. Generally, an application needs to be made with the warrant application to not announce the officer's authority or purpose in searching. So this, the bill as it's drafted repeals that and makes some conforming changes. The amendments, and I'm looking at Amendment 868075/1, affects not only that, but also the time of day that a warrant can be executed and procedures for the execution of a warrant. So if you look at page 3 of the reprint, it's that number on the top right-hand corner. It says below line 13, a police officer who's executing a search warrant may not, for the purpose of executing the warrant, enter the building, apartment, premises, place, or thing specified in the warrant unless the state's attorney or the state's attorney's designee for the jurisdiction that the warrant was issued in has reviewed the warrant, has been informed by a police officer who will be present at the execution of the warrant of the circumstances under which the warrant will be executed, and has approved the execution of the search warrant immediately before any officer enters the building, apartment, premises, place, or thing specified in the warrant. And reasonable notice that a search warrant is being executed has been given to any individual inside the building, apartment, premises, place, or thing specified in the search warrant. This notice needs to be reasonably calculated to alert occupants of the building or place being searched that a search warrant is being executed, and the notice needs to be given at least 30 seconds before any officer enters the building, apartment, premises, etc., being searched. A police officer would be required to wear a uniform or other clothing that makes the officer immediately recognizable as a police officer at all times while the officer is participating in the execution of the warrant, and may not, for the purpose of executing the warrant, enter the building, apartment, etc., that's specified in the warrant between the hours of 10 p.m. and 6 a.m. unless specifically authorized to do so in the search warrant. The officer may not search a building, apartment, premises, etc., until an officer participating in the execution of the warrant has read and provided a copy of the warrant to either the owner of the building or place being searched, or if the owner is not present, any occupant of the building or place being searched. If the place is unoccupied, the place being searched through the warrant is unoccupied, a copy of the warrant is required to be posted at a location where the warrant was executed and in a manner reasonably calculated to give notice that the warrant was executed. There's also a provision earlier in the bill that provides for a court to authorize the execution of a warrant during those nighttime hours, so that would be between 10 p.m. and 6 a.m.
So there are a couple things that I have questions that I see that probably don't make a lot of sense, but then wanted to get the law enforcement officer. I see Bailey's got his light on, but I wanted to get your take on some of the stuff with like wearing the uniforms, time of day, and then additional requirements. And I don't know, we can start digging through the additional requirements that judge would have to sign off on. There's no one thing was teased out during the hearing was that there's no standardization for forms or format across 24 jurisdictions. Like there's no standard issue form. I think generally conceptually it's all the same, but there is no standard. And the information in some instances could be sparse, some could be more detailed. But I think that's a number one thing we need to address. But I did have a question, and maybe I misread this, but what if the owner is the subject of the warrant? Is this subpart 2 for it's really not page 3, it's after page 3.
Right.
So I, subpart 2, subsection 2. Sir, is that's not for the knock and announce, right?
That's for any warrant. So if it's a search warrant, so the no knocks are eliminated. So all you really have with this is knock and announce.
30 seconds.
Right, but it's with the caveat that the notice needs to be given at least 30 seconds before entry. But the search itself can't commence until.
Got it. There you go.
Right.
That's the subpart. There you go. That makes sense. Okay, thank you. Senator, I saw Bailey first, then Jackson.
So I was going to say, this is going to take a little bit of time, I think, for us just to go back and forth. But the first thing that I'd like to start with is on the page 3 of 5, the number 2, has been informed by a police officer who will be present for the execution of the search warrant of the circumstances under which the search warrant will be executed. So if you have an undercover officer, covert officer that's working, and that officer concludes a 6-month investigation, you might have as many as 6. We've had as many as 10 different search warrants being executed at the same time. All the information that was that came from that long-term undercover case came from one officer. That officer is the affiant on each individual warrant. Now that warrant, we do there's a briefing, there's a plan, there's everything, but there's no way that officer can be present at each one of these warrants. And the fact is, when you do, if you have an ongoing criminal conspiracy, and you're going to do warrants, you're going to do them all at the exact same time, especially in today's day and age with the way cell phones are and things like that. Everything has to be timed. We're talking about not just officers getting hurt if we don't do that. We're talking about the public getting hurt. We're talking about everything. So that thing that the officer must be present that signs for the warrant is unrealistic.
So we'd say that. Can you say that one more time? So it's
in that page of the bill. So I'm looking at A1 Roman I. So the Attorney General would have to be informed, or excuse me, the state's attorney would have to be informed by not necessarily the officer who signed for the warrant, but the officer, at least an officer who would be present for the execution of the search warrant. So it could be any of those officers.
So, okay, Jamie, take me to the, I was on the amendment.
Oh, I'm sorry. So in the reprint, I think the language that you're referencing, Senator, is page 3 of 3 in the reprint. It's under section 3523. And is the language that you're looking at in subsection A1 Roman I?
Yes.
So what that says is that that essentially a police officer who is executing the warrant may not enter the building, apartment, et cetera, unless the state's attorney has reviewed the warrant, has been informed by a police officer who will be present for the execution of the warrant, of the circumstances under which the warrant will be executed, and then has given approval from there.
Okay, so we've got 10 different residences that we're going to perform search warrants on. So when we meet with the state's attorney, what that would mean is the affiant and then 10 different officers would have to go for this briefing?
I don't think it would have to be the affiant, because it would just have to be, as it's written, it would just be any of the officers who were were going to be present for the execution of the warrant. So,
So
I think
instead of 11, you could get away with 10 officers?
that's what I was going to say. It would be 10, not 11.
Right, that, I don't understand the need for that at all.
So the policy reason behind that is that that person would be able to provide information to the state's attorney or the designee about the circumstances surrounding the property, just would be able to provide a level of detail and granularity to help that person make a better decision as to whether to grant the warrant or not. And I think that's the policy reason behind it.
So the whole, so the whole situation is the affiant who is going there to get the review of the state's attorney for this situation is the one that knows the case the best, right? So you have the affiant and whoever is signing off on this as that affiant's supervisor, right? They're going there, they're getting the warrant approved by the state's attorney anyway. So when they are going through that process, hopefully you have inner workings with the state's attorney about the warrant, about the criminal conduct of the group, the entire situation. I think if the state's attorney has been briefed about all the different locations and the state's attorney understands it, I can't understand how we would say, okay, yep, we got to take an officer that's going to be present at each one in there to meet with the state's attorney, right? You've got the affiant that knows the most about it. Once they already get the warrant, right, that just makes sense that would work. We're making a hoop to jump through that. And when I'll just wait. So, and a lot of times when you do these larger, this is not an ordinary situation, right? You're not doing these on a routine basis, but this is a situation where this is a criminal, ongoing conspiracy. There's a lot of people involved. Well, if you're going to do 10 search warrants, you might have 5 to 6 officers at each site. So now you're talking 50 or 60 officers that need to be briefed. This is a huge time constraint to get straight. Now all of a sudden, and the other fact is, we've got time limits on when a warrant needs to be signed by a judge and how many days it's good for. To say, oh, by the way, now we've got to work on everybody's schedule, so everybody's got to be there.
No, I got it.
I just don't understand how putting this in there makes this any safer for anyone.
Got it. No,
right. I see no reason for that.
Your perspective is invaluable. I mean, so look, again, for me, it's just on two ends, making sure that the state's attorney's making this decision has all of the information available to that person at the time that they're giving their approval. So the policy reason behind it was just to make sure that happens. So if we could find other ways to ensure that it happens, like making the form more detailed, providing more information, shortening the time of I guess until you have to go back in for another one. I think right now it's 10 days or something like that. If we can shorten the time, things like that, I'm good to go. So I'll yeah.
Right, all of that, and we're happy to discuss that with you, but that's not uniform across the board.
No, I hear you.
It depends what type of crime you're investigating. Then and of course that crime depends on what type of judge that you're going to have, because there's certain circumstances when a district court judge can sign a warrant, some only when a circuit court can sign a warrant. It is completely different now, and that's different when we get into rural areas where judges can be cross-designated. Then you can use a judge of cross-designation. But the dates are different. This is extremely complicated. And to put this extra onus on there of these officers, that we're going to pull 10 people in just for this, is, I think, were the state's attorneys in favor of this?
I don't think they weighed in on this piece. Look, I put it out there for exactly this purpose right
Okay.
now, which is so you're, I'm not wedded to it. Your background and explanations has satisfied me. I mean, like I said, as long as we build in more protections on the application and maybe some time circumstances and time constraints and things like that, but I'm not wedded to it. I get it.
So, thank you, Mr. Chairman. So can you walk me through page 3 of 5, 2, 1 and 2, at the bottom of the page? Trying to understand this 30 seconds piece.
That's just literally like you have to knock and give the person 30 seconds before you breach.
That's pretty dangerous. That's, well, are you talking before they respond to open the door? I'm asking. I'm asking. I couldn't hear you.
Yeah, before there's a response or before you make contact, the person comes to the door and answers. It's just 30 seconds before breach.
Before they breach?
Yeah.
Okay, all right.
Thank you, Mr. Chair. Let me pick up where Senator Bailey left off. My understanding is that when you go to see a judge to get a search warrant, the affiant has to be there. So if the judge has questions about the search warrant, the questions don't really relate to where is it going to be executed, is there a front porch, is there a light, that kind of thing. The questions all relate to whether or not there's a need for a search warrant, what's the basis for the search warrant. So having people who are actually going to go out and serve the search warrant isn't really necessary. What you really need is you need the affiant. So, and that tends to be a single person.
No, point taken on that. And like I said, if there's more information that needs to be provided by the affiant, I think that's more important. Are there any vulnerable individuals?
If we want to redesign the
children
search
present.
warrant
Yeah.
application form to provide more information, that's something else again. But having all these people there in the state's attorney's office doesn't make a lot of sense. Okay, so next, it looks from, as I read the bill, as if all search warrants in Baltimore County, any search warrant, whenever it's going to be executed, daytime, nighttime, no knock, knock, whatever, would have to be approved by the state's attorney. I don't think that's currently the case, and I'm not sure why a judge has to approve a search warrant, but not the state's attorney. The reason why in my omnibus bill I suggested adding the state's attorney was to have another set of eyes on a no-knock warrant. And so we sure don't need another set of eyes on just your garden variety warrant that's going to be executed at 2 o'clock in the afternoon, search warrant. See what I'm saying? So that's number 2. Number 3.
Just again, though, if you, I do think that there's something that happens if you go ahead and get rid of no knocks, and things will migrate over to the knock and announce. And I think more scrutiny needs to be given to the knock and announce because then everything will migrate over. I just to put that in the back, but.
Okay, well, even if, I see what you're saying, but I think you're putting a huge burden on the state's attorneys to make themselves available at all hours of the day and night for people who frequently on fairly short notice need to get a warrant issued, if we enact this as it is. So next, down in, there's no line on here, unfortunately, but it's in section 3-523 on page 3 of 3, down at the end of A, it's A subpart, A1 subpart 2, it says reasonable notice. That word is going to give rise to litigation. The people who are apprehended, the defense counsel, their first motion is going to be to throw it out because reasonable notice wasn't given. And I think we need something more specific than just the word reasonable. The same problem comes up about 4 lines lower in A2, where it says notice provided by the police officer shall be reasonably calculated to alert occupants of the building. Once again, it's great fodder for the defense counsel to say all the products of this search have to be thrown out because there was not, the notice in this case was not reasonably calculated to alert the occupants. And then we have the 30 seconds. And Scott Schellenberger is listening to this, online, and he sent me an email saying, maybe I shouldn't read it exactly the way it was written, but let's just say it provoked immediate response from him.
Okay, well, Scott, at least we did some good work with the Attorney General, Bill, okay?
Right.
Got him off the back with that one.
So, but the point is, if the reason why you want a no-knock is because there are people behind that door that have that are known to be well-armed, the last thing you want to do is to knock on the door and give them 30 seconds to grab their armaments and be prepared to retaliate or respond with force. And this even gets worse on the other page. It's not named at all, where it says down in C1 now, subject to paragraph 2, a police officer may not search the building specified in the search warrant until an officer participating in the execution has read and provided a copy of the search warrant to the occupant of the building. So not only do you have 30 seconds, but now you breach the door, and some poor schnook has to stand there in the doorway reading the warrant and making himself, I guess, a nice target for the people inside the room. I can't understand why you'd have to make him read the warrant. So those are my comments. I've got about 5 comments. Would urge the chair to take them into account.
Absolutely. Okay. I mean, we were just talking about this. I mean, I maybe too much of an assumption, but that I would have assumed that the scene would have been secured and that person would be kind of in custody at that point, and then you're kind of.
Well, the problem is it says that they can't search the building, so you break the door,
Yeah.
you get in, and now you can't do any search until
Well, you
this person
secure
has read
the
warrant.
person, and then you say, look, we're here. This is why we're here.
Meanwhile,
We're going to dig
gunshots
through your
are
stuff
going
now.
off.
Okay. Got it.
Got it.
Senator Huff.
A couple of things. So one, I'm trying to figure out the drafting of this because I think it's kind of confusing in that it starts off in the criminal procedure, which is correct because that's where all the warrant stuff is. And then it jumps to the public safety article, and I'm assuming that's because it used to talk about the Maryland Police Training Commission because that's what's there. But then it goes into more details about how you execute a warrant. So my suggestion would be, whatever we do, we should probably put it in criminal procedure where warrants is, or else it's going to be confusing to people because you're jumping around 2 different books. And it doesn't seem to fit where this language down there, 3523, there's nothing in there about warrants right now. In fact, it's something about officers in school or something.
2.3 should be a vacant section of the code.
Yeah, but if you look all around that code, there's nothing even close to that there. It's like Maryland Police Training Commission standards and stuff. So 3-207 is Maryland Police Training.
No, I see what you're saying, but I'm looking at the SWAT language before, and that's maybe why.
I take it as whatever was wiped out might have been in that section, but I'm just saying for simplicity's sake, if you want people to understand how you serve a warrant, I would put it all here.
No, I hear you. I assume that, I mean, Jeff, we were talking about this, or Wall Street, we were talking this about how, like, things have migrated from SWAT teams to, I assume that maybe that's why, I don't know. But I hear what you're saying. I don't think
It's just a drafting thing, but, I mean,
It's
for
a big
anyone,
deal.
what will happen is this, when you try to draft a bill later on dealing with this warrant, you're going to have this crazy situation where half of it's here, half of it's here. So that's my first thing. Second thing is, I looked up, and unless there's an update, Montgomery County, actually, when they took this up, after you had an incident in Montgomery County, they did not eliminate no-knock warrants. It says the law enacted by the county council doesn't eliminate no-knock warrants, but it does restrict their use. Quote, here's the council that put it in. If there's a hostage situation or some sort of extreme case where people are in imminent danger, of course police can enter. So am I missing something? So Montgomery County, the most progressive county, quote, in the state, did not get rid of it. And the last thing, just to echo the current law is that police have to prove to a judge that there's danger of destruction of the evidence, or obviously danger to themselves or others. That's why they need a warrant. And just to tell you, I mean, 30 seconds is longer than I thought. I mean, you're like, police. I'll tell you when 30's up. It's not there yet. That's 30 seconds. I mean, that's a lot of time for somebody to load a gun, for somebody to dump the evidence. That's a lot of time there. And you're taking officers, you're putting them in danger, you're putting other people in danger. Right now, the standard is they have to go to a judge, and they have to prove that there's imminent danger. And even in Montgomery County, which I would imagine is the self-described most progressive county, they don't even go this far.
No, I would say for the first example, like the hostage stuff, I mean, obviously you don't need a search warrant for that, or, you don't need to go see a judge for that one. But, I mean, the idea of providing the time is that, and then also limiting the time in which you can execute these things. Like if it's in the middle of the night and you're sleeping, you're upstairs, if someone knocks on the door, it's going to take you more than 30 seconds to get up, wake up, understand what's happening, get from one end of your apartment to another. So that's the, I don't know where the balance is, but that's the conversation.
They shouldn't be commonplace. That's why, and I don't know the data. I've trying to look at it. We sent to GoCap that they were supposed to be collecting how many of these no knocks are happening. I don't know if there's a proliferation.
I have some of that. I'll send it to you in a second.
Yeah, they should not be overly commonly used, but I worry about we send somebody to Scarface's lair, with. I think there's obviously circumstances where a no-knock is going to be appropriate.
Well, I was going to ask whether we don't have anything in here about the standards that we're asking them to assess whether it warrants a no-knock, and whether that is something we want to put in here. That says what?
Give me a second.
Danger of life.
I believe it's evidence.
Destruction of evidence.
Yeah, destruction of evidence in life.
Destruction of evidence?
It's in the fiscal note, too, I believe.
Okay.
To justify the request for such a warrant, also referred to as a no-knock, the officer must have reasonable suspicion that without authorization, the property subject to a search or seizure may be destroyed, disposed, or secreted, or the life or safety of the executing officer or another person may be in danger. If the warrant application justifies this request on these grounds, the search warrant must authorize the executing law enforcement officer to engage in these actions.
I would think it would be worthy to have a conversation about whether property warrants a no-knock, or whether it is, safety and security of the officer.
Well, I mean, I don't know. I mean, I think there's meth labs and all kinds of stuff like that, so.
Yeah, I mean,
what do you mean? What do you mean by? Well, I think, I know there's some, the preservation of evidence. I mean, particularly when you're doing the drug raids.
right, but isn't that how we get into these, a lot of the problems when we get there?
Well, I mean, it depends what you want. I mean, you have officers who have a judge that sign off that says there's a drug enterprise at a location, and, some of that evidence that you're asking that you're going to have to bring in court to prosecute these folks to get them off the street, sometimes those, evidence can be destroyed. So that's partly why state's attorneys or judges have granted no-knock warrants. Element of surprise works. It doesn't have to be drugs.
Particularly,
it can be public
right.
corruption.
Absolutely.
Your county executive was flushing cash down the toilet.
It could be corruption, yeah. Well, you just got a county executive. We'll see what happens. But anyway, so at the end of the day, but it's the preservation of evidence, preservation of life, public safety, and those matters. But the criteria that's set by the judges shouldn't frivolously just give somebody that. And I think the criteria is, everything needs to be assessed.
I get it, but isn't that what we're trying to, I think, trying to tighten this up?
No, and I'm not against tightening up or reforming it. I'm just trying to answer the question on why sometimes we have, no-knock warrants. Some people say you should get rid of no-knock warrants. I say conversely, maybe you need to narrow the scope of no-knock warrants.
Right, that's what I'm saying.
Narrow the scope, because there are times when you need that element of surprise.
I agree.
You knock on the door in the middle of the night, commonly it depends on what type of unit you're with. That unit is out there certain hours for the element of surprise. 10 o'clock at night. Some folks go to bed at 2 or 3 o'clock in the morning, and they may have you may need to make an arrest. You may need to gather some evidence that goes along with the case, and to knock on the door and give them 30 seconds to get themselves together. I mean, I understand you want to make sure folks can gather their thoughts and get up, and come in to answer the door, but not everybody wants to answer that door. And so 30 seconds, as was displayed by Senator Huff, is a long time. It's a long time. And you have these officers, if you're in an apartment building, where are they gathered? In what we call a fatal funnel, which means they are there. Someone comes to, I'll give you a case in point. Howard County, we're searching for, along with other law enforcement officers, we're at a hotel in Howard County out by the Laurel Racetrack. And a guy had already shot, we were searching for him. He wanted in multiple jurisdictions. He had shot an officer in D.C. My SWAT team and others, and the investigators had tracked him down to that hotel. And as they approached the door of that hotel, as they're searching multiple rooms, he had a weapon that could penetrate those doors, those hotel doors. One of my officers got shot and almost got killed that day. So those things can happen at any time. But I think we do need to tighten up to make sure that we are accountable and that we can articulate why a judge, why the request was made, first of all, why the request was granted, and how we can track those things.
No, I totally understand that. My point was only, and I think when weapons are involved, it's a totally different thing. But if you're talking about non-weapons or things that are evidence that's in there that is not of danger to the officer, that to me is a different.
And that's where the qualifiers come in. So I think there are a number of bills that are out there that kind of change the quantity of drugs to, well, there's also some qualifiers in the industry that says if a person has, you can qualify a residence or a place to be, an enterprise because of the amount of drugs that's going through there. Now, they may or may not have weapons there. They may or may not have dogs there. They may or may not have a booby trap. But that will constitute why I would send a SWAT team in there versus plainclothes investigators or whomever else. And so, but accountability is key. I mean, I think, this deliberate process is worthwhile because, the intent of what we're doing here is right. We just need to make sure that we're not causing undue harm to the folks that we are expecting to, rid our communities of this type of folk. That's all I'm trying to say.
Thank you. So, there's an adage that says when the only tool in your toolbox is a nail, all your problems, or is a hammer, all your problems look like nails. And sometimes I think that in the General Assembly, because our toolbox has words and money, that we have a tendency to try to drown every problem we see in words or money or both. But I think we really ought to, the KISS principle very often applies, we ought to at least consider the KISS principle and try to legislate minimally rather than in fell swoops. And that's why we come back every year, so we can try and see what works. In this case, what has been suggested by the state's attorneys was just in all counties, require the state's attorney to sign off. And what does that bring to you? Why is just having the state's attorney sign off, why would that make much of a difference? And here's the reason. Because currently, the person who signs off is a requesting officer. And it's pretty easy to just say, when that search goes wrong, that's Sergeant Jones. It's hidden. There's nobody, he's the guy responsible for it. You say, darn, Sergeant Jones, you probably shouldn't have done a no-knock, should you? There's nobody at the top. People at the top can insulate themselves from responsibility. But by just simply requiring the Office of State's Attorney to sign off on that, when that thing goes wrong, people are going to say, well, wait a minute, you signed off on it. You're an elected State's Attorney. You signed off on it, and let's start digging in here. And you just can't say, well, that's what Officer Jones did. What are you going to do? He has discretion. So I think just that one, we're trying to micromanage here and how police do search warrants. This is scary stuff. It's tough to do by rule. Such a fluid situation. Rote rules are so difficult to come by. But I really think if we just have an amendment that had been suggested by some of the state's attorneys that just requires a no-knock warrant to be signed off with approval by an assistant state's attorney, you're going to get, if that thing goes wrong, that state's attorney, that elected state's attorney is going to have to explain why they approved a no-knock warrant under those situations, and now somebody's dead. I just suggest to you that just that one important tweak would reap huge dividends here, and is probably enough to just put the kibosh on Sergeant Jones, who just likes to do no-knock warrants and hates to bang on the door, because that state's attorney is going to be very risk averse to this stuff in every jurisdiction. Thank you.
Thanks. Thank you, Mr. Chairman. I like a lot of what you did to the bill. I agree with the concept of the state's attorney signing off. I'm not conceding that we need to keep no-knock warrants, but I just wanted to address what Senator West said before, because he said, oh, it'd be a tremendous burden on all of the warrants. Maybe it will. I'm still fleshing this out, but, I'm thinking it wouldn't be all that much of a terrible burden, because just like you have a duty judge, couldn't the state's attorney just designate the duty state's attorney for, if something should come up during this time? I don't know that it would really be that tremendous of a burden. I'm not arguing. I'm just suggesting that I don't know that it would be that tremendous of a burden. Judges have to be on duty for these things when they come up. So to have a state's attorney be available, not the state's attorney, but the designee, I don't know if it would be the tremendous burden that you think it would. I'm not necessarily asking for an answer yet because I'm not quite finished. I think that there is, believe it or not, some merit to the concept of the 30-second wait. I agree that there should always be a knock and announce and some notice, but I don't know that 30 seconds is reasonable in all the situations. And the final thing that I wanted to suggest is that if for some reason this committee should back away from eliminating no-knocks, as several other states have already done, and we don't know of any tragedies that have occurred because they've backed away from them, I would suggest the state's attorney approval, and I would also suggest, as Senator Hellman, I think, was suggesting, I think that you were going in this direction, and you may have even said it, Senator Hellman, that we would narrow the scope and eliminate destruction of evidence when that evidence might be drugs, and that wouldn't be unprecedented because that's already been done in at least one other state, Utah, and maybe others, but I only know of that one state that said we'll still do no-knock warrants, but not for drugs, not if it's destruction of that evidence. And as Senator Sidnor, I think Senator Sidnor said, the brilliant Senator Sidnor once said, if those drugs are destroyed, isn't that ultimately a good thing? Because that's less drugs that'll be on the street. Even though I think that was refuted by a state's attorney. But so those are my thoughts, just sharing my thoughts. I don't know that we need to do the 30-second wait. I do think that we need the knock and announce. I do think the state's attorney approval is a good layer that we should add.
Okay. So I've been listening to the conversation. My conclusion is that we should focus on tightening up the circumstances in which no-knock warrants can be granted, rather than trying to prescribe limitations on the way in which no-knocks are executed. For example, we could specify criteria for the issuance of no-knocks, which would, for example, include situations in which the people expected to be present in the building are believed to be armed. I mean, and we could come up with other criteria as well, which would seriously limit the number of no-knocks which would be issued in any political jurisdiction to the most serious situations where you really think you're going to have a no-knock warrant, rather than try to put 30-second time limits on what has to happen after they knock.
It's a good idea. All right, Senator Bailey, then Senator Huff.
So I think I'm leading into probably his issue here, but the thing is, I just was waiting until you were ready. So the thing is, as far as, I worked as a federal task force officer. So I have seen this from the federal side and the state side. And there are many requirements if you're going to do a federal search warrant, right? And one of those is it has to be approved by a U.S. attorney, right? So I don't see that that's a big leap to make a state's attorney approve a warrant. One of the other things that you have to do is you have to make sure that every single officer, and that's the way that I read C, every single officer has to read the entire warrant before they're able to be on the scene, right? Before they're able to be involved in the execution. C doesn't say that they have to read the warrant to the bad guy. What it says is the officers that are going to be serving the warrant have to read the warrant, which is also a good thing. And all it says is you just have to leave a copy of the warrant with the people. You don't have to read the warrant to them. I mean, that would take forever. A lot of us don't live in city environments. So when we put this time limit on here of 6 a.m., well, I've got to tell you, if we do 6 a.m. where I come from, by 6 a.m., the people that are headed up the road, they leave at 3:30, right? So by 6 a.m., they're gone, right? You would have to do the warrants, and but that comes into the due diligence of the police department. If you're doing a search warrant, you're watching these people most of the time. You have some true knowledge. You should be able to go to a judge, and based on the facts of the case, you should be able to explain to the judge, hey, this guy leaves every morning at 3:30. We know that we pick him up at 3 o'clock in the morning, especially if it's an arrest. A serious issue where you want to arrest him. You don't want to hit his house and wait till 6 a.m. and him be in the wind, for 3 hours, and then you've got to go find him. That just makes a dangerous situation. I think the fact is the time, I do have some struggle with the time, but the thing that I think might be easy to do is the department should have an entry plan. They should have an execution plan. They should have a plan that they have to explain. And I'm going to tell you, this is not something departments don't have. They have it. They have a plan for every single officer already. You just haphazardly, this is not like Chicago PD where you show up and you just, half a dozen of you run in, you grab the back, we grab the front. That's not the way this is done in today's day and age. Unfortunately, I'm old enough to remember those days, right? And it was daggone pretty scary sometimes when you go crashing through the door and you have no idea what's going to be on the other side or what you're going to find. But the thing with the time is, when they're sleeping, it really is easy when you're in there to get some bad people, that it is a safety issue with dealing with them when they're sleeping rather than if they are awake. And when you're dealing with 30 seconds, if somebody's awake during the time frame, it's going to be a gun-on-gun situation. We're going to have more violence, in my opinion, when it comes to this scenario. So I would be more than happy to work with you on this and some of these raid plans, but I just don't think this is where we should be right at the moment.
so based on the conversation, I'll say like I'll talk to, see what Senator Carter, see what you think. I want to get I mean, this is my amendments to your bill, so I want to see what you think about, what I'm offering here, but.
About your amendments?
Yeah, but no, you're next. Senator Carter's next. Before I do that, Senator Huff.
I was just say, I don't think this is ready for prime time. I mean, I got questions about that it's drafted in the right place. There's lots of good questions about, and this is a life or death issue. If you do this wrong, somebody can get killed. So I just make a motion we can table this and move on. People can bring back their amendments. We work on this later, but this is too important. This is not ready for prime time with the amendments and what we've got in front of us. This needs to be worked out correctly so that we don't, this is a life or death bill. And so this is not something that I think we should be cobbling together on the fly here. We need to get amendments. We need to get feedback from the stakeholders on this, and then we need to move forward.
So I just resist the amendment because I think this has been good. We've had a work session and we're doing this now. I think we can dispense of a number of the things, at least in my amendment, okay? And then either choose to adopt, and then we have a framework.
With all due respect, I'll press it because I think we need to be working off of something that is in my opinion, a reasonable path forward. And I don't want to sit here tonight drafting on the fly something of this importance. So I'll press it if there's a second on it.
So it's been seconded. We'll, I'll obviously look. Everyone gets to entertain the motion. So we can do it either by roll or you can do it by hand or voice. Sure, we can discuss it.
We have one or two other bills that we could take up tonight. The Baltimore City Policing Bill, for example. I suspect we can achieve general consensus on that. And then it's a little late. Wouldn't it make sense just to take one or two other bills that are easy and dispose of them, and then come back tomorrow and deal with this? In the meantime, maybe Jamie could try to do some drafting to incorporate some of the ideas that have been brought out.
I think we'll do this. Let's do this. I do want to, on this amendment, because I have some ideas based on the conversation. We can make some progress on this amendment tonight, and then we can do that. That's why I tried to move to the AG and something else like this, because I thought we could make some good progress on it. For the, as a sidecar conversation, just for the Baltimore City, I'm looking at the Baltimore City Senators. For the Baltimore City Police Department issue. So look, we got the amendments proposed. We have the bill. So the bill is ours now. And we heard from the chair of the city delegation present the bill in favor of it. So I don't know what's the deal, but I'm not sure I'm in receipt of the letter. I don't think we have the. We'll double check. We're checking right now.
You're right. You said we haven't had a hearing?
So wait, how do you have the hearing in our committee first and then?
I don't know.
All right, look, the only other thing that falls in the category, we figured out the Baltimore City thing, is body cameras, which is easier than no knock, but not easy. So, yeah, we're going to get one more bill done tonight at least. So if we could push through on this for a little bit more and then move to body cameras. Is that amenable? Are folks amenable to that? Mike?
I'd rather, if we have language, the language people are talking about is state's attorney, people are talking about totally different language isn't in front of us.
For what? For
the no-knock warrant thing.
No, I have a couple things just to clean up on this amendment based on the conversations. I think you'll be fine with what I'm proposing
All
here.
right, I'll withdraw my motion.
Got it. And then we can move on to body cameras if that's amenable to you. So then the most important decision of the night is, look, there will be a menu coming around. It's not an indication how long we're going to be here, but there's a menu coming around. If you want to, we're going to have someone pick up dinner for folks on me. So if you just want to select what you want for dinner, again, not an indication of how long we're going to be here, but if you want to select what you want for dinner, go ahead and do that. I think the menu's coming around soon. All right, we'll wait for Senator Carter to come back, then we'll go real quick. Okay. So look, just based on the conversation, just real quick for the amendments, so then we can build off of those when we come back to this. I'm not sure what else we need to work with in terms of action steps, the next action steps, but for the all right, so for the actual approval process, having the officer present, the officers that are going to be on the scene, I'm fine with striking that because it does pose a logistical concern. And if you have the state's attorney sign off on it as well,
So I actually thought you did mean Affion.
can you get,
So the Affion.
Yes, the ones,
just the Affian, because I mean, that they know the case. I mean, they're the master of the case.
I
of the
also, though,
situation.
to be truthful, I didn't fully understand, I didn't really really understand what Senator Bailey was saying. I felt that the way that the wording of this bill was, we were only talking about one of them. I didn't really read it, that it was talking all of them.
No, you're right. So it was, but he was saying that what if you have a situation where you're doing like kind of a citywide deal? You've got 4 or 5 of these things going on in the same, then you've got
That's fine.
one from each.
Affian.
Okay.
This is only for no-knock.
This is only for no-knocks. Yeah. Not
Okay,
for, yeah.
but we're not doing no-knocks.
We'll see. I mean, this is just the amendment. This is not the bill. And Senator West will work on the reasonable language when we come back.
Shouldn't the reasonable language that Senator West was talking about coincide with the amount of time that you spelled out in the bill?
Yeah, so I don't know if the timing thing is interesting because just based on the conversation in the hearing and then in the work group and then here. So for me, I'm fine, like what Senator West was saying. If there's more stuff on the front end in terms of the criteria, and I'm fine with. I mean, it's my amendment, your bill, but I'm fine with that coming out of the amendment, frankly. If we make sure there are adequate checks on the front end to get it. So.
I think I'm fine with that too. I think, if I'm interpreting what you're saying correctly.
You guys just write this crap up. I mean, I just feel, I mean, Senator Carter brings a bill in, and now somehow she has ownership of it. I mean, that's not how we've ever done this committee before. If you throw a bill out, once you introduce it, that's not your bill anymore. And now we've got this new, it's my bill ownership stuff. I mean, you throw something out. I'm just.
Oh, look, as I had this amendment.
It's okay with you. Never.
Just want her. Understood, but I'm just asking. Same thing for Bailey and Jackson because they know more about this than I do. I've just been asking, like, hey, what do you guys think about this? What do you think about this as sponsored bill? I just want to know. So, I mean, I'm just asking to see what people think.
I got right to an opinion.
Can I reverse it?
Yeah, sure. Go ahead, Senator Walter.
I just kind of want to reverse the conversation. Perhaps instead of thinking what we should take out of the amendment, we should think
back
about
into the-
what we want in. Like, what's crucial? Like, to me, I'm with Senator Cassidy. It's crucial for any no-knock to have state's attorney approval. And I don't think it should be assistant state's attorney. I think it should be state's attorney. And if it's in the middle of the night and the state's attorney's asleep, you can have a designee. To me, no-knocks are dangerous, dangerous things that should be used extremely rarely. And there should be a supervisory officer saying okay, and there should be eyes on by the state's attorney. To me, that's key. Everything else we should discuss, and that's a legitimate, but it feels extraneous to me. That's the core part of what we're trying to do. And then we can kind of layer on and see, like, well, where is the gravity here? What do people feel to be core to protect officers and our constituents in no-knock circumstances?
We're not adding anything yet, we've been talking about it. I think it's a good idea. It's adding it to the judge, yes. It's on top of.
You have the judge, then you have the state's attorney.
Senator Bailey was next.
So, Senator, I would say that I don't know that I think the elected state's attorney would be the one that we should require to sign every search warrant. Because if we go to a big county, right, that's a pretty unrealistic thought process.
Didn't we say designate already?
Or the designee.
I thought the senator just said he wanted the state's attorney, not a designee. Right, and
So Senator Cassidy and Senator Walsh, they both said or designee. Is that right?
And Senator Carter said.
And Senator Carter said that.
so because many times when you're dealing with like let's say you have a task force that's working, there's already, if it's in that county, that state's attorney's already assigned a state's attorney to that group of officers. And that, because they want, if you're doing covert buys, covert relationships, they want to know exactly what is going on because they're the ones prosecuting the case already. That state's attorney that's working with those people should be the one that should be just signing off on that search warrant. And in my experience, that is most of the time occurring. Very seldom do you do a search warrant that you just randomly go do a search warrant without any input from the state's attorney, right? Especially any such thing like a no-knock. You are going to be using the state's attorney in those situations, and that's my experience, and that's what I've seen, whether it be in the state side or the federal side.
Thank you, Mr. Chair. Just to pursue the front end conversation further, I mentioned earlier people who are assumed to be armed would be a pretty good reason to allow a no-knock. I was trying to think of others where it would make sense. I looked online and I found lots of them were issued in connection with marijuana. I think we should leave that out. I mean, it seems to me no-knocks have resulted in lots of officer deaths and lots of the deaths of the people in the building. And to do that for marijuana, it seems to me, is an overreach. On the other hand, fentanyl, large amounts of other toxic drugs like cocaine, maybe we'd want to include that. But beyond that, I have a hard time thinking why we would want to do no-knocks at all. If you really just want to apprehend the human being, you could do that during the daytime. In many cases, unless they've got guns, and if the guns you want to go in the middle of the night when they're asleep. So that just my thoughts on this.
Follow up on that and say, like, imminent harm to somebody else. But I agree with firearms. I don't really agree with drugs. I mean, I don't think you need to do it, right? And I think we want to narrow it, unless or explosives or, you know.
It's going to be difficult to capture, right? Because you don't, where it says property, everyone's thinking of drugs, and maybe you don't want no-knocks just to prevent someone from flushing cocaine down the toilet. But property also could be evidence of a serious crime, right? It could be a bloody knife. It could be a gun used in a murder. It could be money that was stolen from a bank robbery. So we can't totally exclude all property and only include like firearms that are going to be used against the officers doing, because you have to have the ability to prevent the destruction of evidence of serious crimes. And I agree with you that I don't. Well, that's fine. I didn't want to be too categorical about it because you're encompassing things you don't want to encompass.
Evidence linked to a serious crime. Or, you know, I don't know the language, but.
But wouldn't this be a better conversation to be having than trying to talk about how many seconds you have to give notice?
Hi, thank you. Thank you. I think you probably want to say something like elements of the crime indicated or the targeted crime. So when you go to the judge, you go to the state's attorney now to say, hey, we need to get this warrant. And, because you're going, so the key is, the urgency is to preserve the elements of the crime or elements of, while you're there. Now, the fact about drugs and marijuana, marijuana is still a scheduled drug. So we haven't gotten to that point yet, but, there are a lot of folks who arm themselves when they are out dealing drugs. So sometimes those weapons come from that. So I think you're talking about a scheduled, a scheduled drug, or there's a category of it. So I just think that we can't just be dismissive of drugs. We're not there yet. We're getting there, though.
So I think it's important. So I think it's important that when we think about this and we talk about, what are we going to say qualifies? I think we should really concentrate on what the current laws are, such as the rules of arrest, right? And what's the rules of arrest for controlled dangerous substances? Any controlled dangerous substances under Maryland law is treated as a felony, right, under rules of arrest. So that's where we should, we should take some time and look at that, because that's what's going to, that's what a judge is going to be looking at. That's what the state's attorney is going to be looking at. That's where we should have our focus on rules of arrest.
But then he goes back to the marijuana thing. So, like, if it's schedule, like, marijuana is still Schedule 1, right?
That's correct.
So for marijuana, you want to do, like, that's, for marijuana?
What we should be looking at is the rules of arrest that apply when we're talking about, because you can have quantity, right? And if you're dealing with a significant amount of quantity, then you're dealing with, you could be possibly, quite frankly, dealing with a cartel, something of that nature that we know operate in and out of the state of Maryland. That is something that, it was just marijuana, but it didn't, it didn't matter that they still had, $500,000 in there and the scenario of all these guns. That is not something that we want to overlook.
Well, all right. Well, let's just do this. There are a couple points we can agree upon, which is the state's attorney and the designee, or the state's attorney's designee. All right. So if can we just adopt that amendment? And I know that Senator Carter also agreed to that amendment. Does it look like that's going to be rally?
I mean, that's fine.
Okay, I just want to make sure everyone's present, so I'll be right back. All right, looks like that's adopted then. We'll adopt that.
Good job.
Freestyle work there. All right.
We got the original amendment and just insert that one line.
Yeah. All right, we're gonna.
For people watching, do they realize that we've been at this since 9 a.m.?
Yes, they do. We are a mere 20 minutes away. So we're gonna wait for Senator Hellman to come back to continue the discussion. So we'll take just a pause here for a minute. All right, let's press on here. So, Senator Wallstreet, anything else? What do you have? Do you have anything else? Do you want to offer?
On this?
Yeah, tons of stuff.
Are we moving?
Yeah, look, we've got some good suggestions for the this no-knock bill, Senate Bill 419. We'll work up some language for the committee's consideration. We'll go to Senator Jackson and Senator Sidnor, and then we are closing in on the end of our day here.
So
yeah, of course.
I apologize, we were talking about it.
No, it's great.
So I think if it hasn't already been said, I think 30 seconds gets you killed, sir. I think that's something we need to really, 30 seconds will get you killed. And I think that the fact that, we are moving toward body cameras, which means when the officer knocks on the door, all that's recorded, so you know the officer knocked on the door. If it's so he's knocking and he's announcing, so we will have that recorded because in other legislation. But I think the element of surprise is a must when you're looking for folks on felony warrants. So we just need to keep that in mind. But we have some checks and balances with the body camera. Those guys had that. There have been regulations since 2016 on SWAT raids. So these are things that we can incorporate as we're doing that. But I think if a person has to wait 30 seconds, I served most of my career in warrants and fugitive. That's not we need to think about that. So thank you.
No, I think the committee's pretty settled on that. I'll make sure that that's, at least in my amendment, will be stricken from the amendment when we come back for consideration. I think folks are pretty settled on that. We've got everyone here, so any other further discussion on that, you all? Senator Sidnor or Senator Jackson?
Thank you. No, I just wanted to kind of stand in solidarity with my Baltimore County folk, and you too. I think what they said was extremely reasonable. And he was the first one I'm listening. Like, yeah, you're right, Chris. I mean,
Senator Westlake slowly melts into the background.
I think what they said was extremely reasonable. And I mean, if it's going to be about property, there's some property that, again, the question is it worth putting an officer's life at risk for? That's how I look at these things. And I think given the way that we're moving, things like marijuana, absolutely not. Well, I mean, to have an officer killed for something like that, I think is ridiculous, for something that's extremely riskful. I mean, it has a lot of risk, so that's it.
It all sounds extremely reasonable to me. Senator Hedelman.
Preservation of evidence. And I think there has to be some measure of imminence. Like, why does it have to be a no-knock, right? There has to be some indication that there's some threat to that, in my opinion.
Agree. Okay. Well, with that, I was going to say, again, committee, thank you so much for the work. For the people watching, we've been here since 9 a.m. grinding. So just want to say thank you all for sticking with it. And what time is Florida tomorrow?
Tomorrow, I just got an email from President Ferguson. So testing site is opening at 10 tomorrow. Therefore, they're going to proceed with a floor session at noon. So do you want to vote before?
So could we do, how do folks feel about 10 o'clock tomorrow?
People are going to just have to slip out to get tested.
You get tested at 9, between 9 and 10. No, oh, they open at 10.
They open at 10. So
About 10:30?
you can start at
Yeah, 10:30, give you half an hour to get tested. And that gives us an hour and a half before floor. Is that,
Okay, what are we gonna take up when we come in for that hour and a half?
so we're gonna, I think, well, we'll work on some stuff for the no-knocks. I think we should continue this conversation. Is everyone good with that? All right, so 10:30 back here, motion to adjourn.
Second.
Boom. See you all later. Have a good night. Be safe.